let's just wait for a minute. Good evening, friends. Let's just wait for a minute for the participants to join. Here we go. Just after the Christmas holidays in 2025, early 2026, when the court reconvened, the Apex Court delivered a historic judgment in Tiger Global, expounding on treaty interpretation, tax avoidance, and GAR. That judgment is still being discussed and debated. What a historic judgment that was. And just a few days before the Supreme Court broke for its summer holidays, now being called as partial working days, in the last week of May, the Supreme Court delivered yet another epoch-making judgment. This time on an issue that the industry, especially the gaming industry, was watching with bated breath. Yes, GST on online gaming. The constitutional validity of the rules, especially Rule 31A, game of skill versus game of chance, a debate that never goes away or never seems to go away. Do past precedents hold when the law has changed, circumstances have changed, times have changed, and what exactly is the legal nature of the activities sought to be taxed? A 417-page judgment decisively in favor of revenue, overturning the Karnataka High Court judgment on this burning controversy, which stakes involved possibly up to 80,000 or 1 lakh crore. But what an extraordinary case. What an extraordinary verdict, and it's one for the ages. Instead of talking about the judgment and what it holds, I think I'll go to the preface of the judgment authored by Justice Pardiwala and Justice Mahadevan. Here is the preface, and it's worth dwelling a minute or two on this. And the preface says, this is how the judgment starts. Few questions in fiscal jurisprudence have generated as much constitutional significance as whether activities traditionally understood in one legal context undergo a transformation in their legal characterization when mediated through technology-driven commercial structures. From traditional forms of wagering and gaming to contemporary digital platforms facilitating online participation across jurisdictions, courts have repeatedly been called upon to delineate the boundaries between skill and chance, commerce and speculation, regulation and prohibition. The advent of online gaming has brought these questions into renewed focus, requiring established legal principles to be applied within an evolving technological landscape. This is the preface to the 417 pages judgment, which has gone, once again, I repeat, decisively in favor of revenue. But what does that actually mean? We need to decode the verdict because it's in batches. It deals with the gaming industry, it deals with the casino industry, it deals with valuation rules, it deals with the constitutional validity. It also overturns, I think, the Madras and Karnataka High Court judgments on horse racing, if I'm not wrong. So, a multitude of issues, all argued by an array of senior counsels on one side representing the taxpayers. I think almost 30 senior counsels representing the taxpayers on one side. And here it was ASG N. Venkataraman right in front of us who championed the cause of the revenue in this monstrous batch of cases, hearing lasting well over a couple of months, and which the verdict has gone in his favor. I'm not sure between MFN, Tiger Global, and the gaming batch, which one does he consider a bigger win? But if anyone could have pulled it off, it was and it is ASG and Venkataraman. With this, of course, he was a great lawyer. Even before joining the government service as ASG 6 years ago, and with the sort of improbable wins the improbable wins over the last 5 years in historic tax cases, ones which will be remembered, interpreted, followed even 50 years later. To be part of them and to be on the winning side, nothing less than extraordinary. He joins the pantheon of legends at the tax bar, and what a privilege it is to host as great a lawyer as ASG N. Venkataraman. Well, when we talk of lawyers, many a times, we forget the tough task that is before the judges. And here I want to definitely take a moment to acknowledge the contribution of Justice Partiwala and Justice Mahadevan to tax cases. Over the last 4 to 5 years, we've not had too many tax cases, especially precedent-setting tax cases that have come from the Supreme Court. But if there has been an exception, it's been the bench of Justice Partiwala and Justice Mahadevan. I always remember this old adage in cricket that great bowlers hunt in pairs, be it Glenn McGrath and Shane Warne, Curtly Ambrose and Courtney Walsh, be it Kapil Dev and Srinath, whoever it may be. But great bowlers hunt in pairs. It's true for great judges as well. When you have a great bench in front of you, even the biggest of tax controversies, even the most difficult constitutional questions get answers, and get answers in a way that vexed controversies and vexed issues get solved or get resolved one way or the other. And I believe if you read judgments of the bench of Justice Partiwala and Justice Mahadevan over the last 24 months, and I have had the privilege of reading several of those tax judgments, not just Tiger Global and Gamescraft, but many other, be it civil law, criminal law, constitutional law, tax law. I must say it's always a pleasure to read cases which set precedents, solve controversies, and give everyone guidance of what is to be done when complex legal issues are involved. Must make a special mention of Justice Partiwala and Justice Mahadevan's bench. We have 75 minutes to listen to the ASG. Very busy day for him as always, despite being partial court working days. I'll hand it over to him for a minute. I know there are a lot of questions. Please put them in the Q&A box, and we'll take as many of them as we possibly can at the end of the webinar. ASG sir, always a pleasure to host you. I don't want to spend even half a minute with a formal introduction of yours. This is an audience that knows you too well. Many of them know you for decades, but it's an absolute pleasure, sir, to hear from a legend like you. Any questions, comments, please put them in the Q&A box, and we'll get those questions answered right from the mouth of ASG N. Venkataraman. Once again, welcome to this special Taxsutra webinar on decoding the Gamescraft judgment, GST on online gaming. Venkat sir, over to you.
Sharada Sharadamboja Vadana Vadanam Bujai Sarvata Sarvata Smakam Sanvitim Kriya. Dear Arun and dear colleagues, distinguished guests, and friends and well-wishers. Happy to be back in a Taxsutra webinar and trying to understand and comprehend one of the masterpiece judgment in indirect tax law in the recent years. The judgments, two concurring judgments, authored by Honorable Justice Padiwala and Honorable Justice Mahadevan. Arun is absolutely right in saying we as counsels, we need to slog it out for our own duties, our own obligations, or for any other reasons. But to sweat it out and write not just a 417-page judgment, but a 700-page judgment. The main judgment of Honorable Justice Padiwala is about 230, 240 pages. And the concurring judgment of Honorable Justice Mahadevan is again 417 pages. It's almost 700 pages. Not a ratio repeated, not a sentence repeated, filled with so much of value content and with futuristic purpose and perspective. It's not just validating a judgment or two or pronouncing the law or ratios of what they feel is right. It will be legendary. It will remain as a legendary judgment for times to come, for the simple reason that the effort the learned judges have put in to deliver this masterpiece. So we owe it to the Honorable Supreme Court and the Honorable Judges. Two, a judgment of this quality and jurisprudence would not emerge unless a battery of counsels have toiled for it. It was such a pleasure. It was such a big learning experience. Name them in the Supreme Court. Any top senior counsel of the Supreme Court had spent his valuable or her valuable time in arguing this matter for the trade. Trade got their best counsels, best assisting counsels, best AORs, so many legal teams. It was a very, very crowded court for almost 32, 33 days. And they put their best foot forward in every possible uh, uh, perspective they can promote to win the case for their clients. And the greatness of this judgment is each and every issue raised by the trade has been addressed comprehensively by both the learned judges. So we owe a deep gratitude to the Honorable Supreme Court through their Honorable two judges, and equally to the trade for engaging their best counsels in bringing out the best points possible. These are two good reasons for such invaluable judgment for us now to discuss and comprehend. And happy to say, today I requested Arun for tomorrow. He said we'll have it today. This marks 23 years of independent practice, started in June 11th, 2003, after remaining as a shadow to my senior, Mr. Late C. Natarajan. And therefore take this opportunity to dedicate both these judgments at his feet, but for whom world would not have known what N. Venkataraman or who Venkataraman is. I owe my professional existence, my spiritual existence to my Guru, the Saint of Shringeri, and my professional existence exclusively to my senior, Mr. C. Natarajan. With these emotions, let's understand what this judgment seeks to say in terms of its invaluable, uncomparable ratios. Let's state first the judgment of the Honorable Justice Padiwala. Before we go into the judgment, I want the listeners to first understand this narrow issue, which has now become such a big constitutional issue and such a big statutory issue. Let us apply common sense law, because so much of prejudice is cast naturally when a trade loses, whether it's direct or indirect. Lot of things happen. It has now become a matter of practice, and we are used to it. So it doesn't matter. So ignoring all that, overlooking all that, let's apply what the judgment seeks to state. And before that, ask a simple question to yourself. Touch your hearts and answer the question. When you stake on a game, whose outcome is uncertain, why do you stake? You stake only because the outcome is uncertain. Tell me one game in the world where there is 100% predictability and still people would stake. Tell me one game in this world. It's not possible. You stake only because the outcome is unpredictable. Therefore, when you stake on an unpredictable outcome, can we bother to distinguish them on the ground? No. Game of skill is out of the ambit, whereas game of chance could still be betting or gambling when the outcome is uncertain in both. Take a game of chess, most skilled game. Can you predict the outcome of any chess game? And take Teen Pati, from the start, it is unpredictable. When somebody puts money on it, can someone say, no, there has to be basically a distinction between the two? Let's apply common sense before we apply legal sense or constitutional sense. And then frame this attitude in our mind as we progress to understand what this judgment seeks to unravel. It starts by classifying the whole process into three broad buckets. When you play a game of skill or a game of chance without any stakes, then law is non-cognizant. It just quietly leaves you at peace because there are no stakes involved. Two, when you pay an entry fee or a participation fee to participate in a game, then the law recognizes it as a right to participate and not a right to recover money of a higher stake. So, entry fees, it is nothing but a participation fee. You enter into a competition, you need to pay an entry fee to enter into the competition, but you win, you become a winner, you get a trophy, you get a check for winning the trophy, then it is not actually trying to secure something disproportionate to what you stake. So threshold entry fees have been taken out of the ambit of the law. But with one difference or one exception. If an entry fee, call it in the guise of an entry fee in the game of a chance, but still secure a prize money, naming it as entry fee, but the outcome is a prize money, then courts have declared it to be only nothing but stakes and not an entry fee, and therefore in the nature of betting and gambling. This is the second bucket. Now, the third bucket is where you actually stake for a return, whether it is a rummy, whether it is chess, whether it's cricket, or whether it's casino, or whether it is steampath. You put the money expecting that you will get a larger return. You may play it purely as a game of chance, or you play it purely as a game of skill. When the outcome is uncertain and you bet on it, then the law triggers by declaring it as betting and gambling. These are the three broad buckets which we need to basically focus and understand before we venture into what this court judgment, both the judgment seeks to say. Now tell us, once we understand these three distinctions, before we go into the judgment, what has been the global practice in identifying these games in various jurisdictions? We placed 150 years of jurisprudence across the globe. 150 years. Only two broad buckets. Bucket one, world does not see any distinction between a game of skill or a game of chance if stakes are put in that for an unpredictable outcome. No difference. Two, the only exception across the globe through legislative process is while defining gaming, they have chosen to protect games of skill played with stakes from being treated as a penal breach or to treat them with penal consequences. Protection has been given in India and elsewhere. So, a game of skill where stakes are played for an uncertain outcome is still betting and gambling. That is why you are protected. So, you will come under the layer betting and gambling, but you stand protected when it comes to a game of skill. So protection once removed, then the difference between a game of skill or a game of chance loses any significance or relevance. Underlying object is gone. Underlying game, nature of the game's purpose is gone. So protection is limited to a statutory mandate. So 150 years of jurisprudence has brought these two features to this particular branch of law. Both are betting and gambling, but skill seems to be protected in ancient days. Fine. Having known 150 years of jurisprudence, let us understand what is the constitutional theme. That's the second which the judgment seeks to say. Honorable Justice Pardiwala has authored the judgment from the constitutional perspective, and Honorable Justice Mahadevan had dealt it from the statutory perspective. After holding also the law to be constitutionally valid in terms of the GST legislation qua the Constitution under 246A, read with 366 and 366-26. So to that extent, that judgment also deals with the constitutional issues. But the main lead judgment deals with purely from the constitutional perspective. Therefore, then the second theme they take into hand for consideration is, look here, what is the founding fathers' intention as far as betting and gambling is concerned? What have they spoken in the constituent assemblies? Three speeches are quoted in the judgment. One by Mr. H.P. Kamath, who said, this is invasion into privacy, keep away. State should keep away from all this. That was his suggestion. The response by T.T. Krishnamachari was, as he then was the, I think, finance minister, came back and replied, no, this is at the Constitution Assembly debate only. He later became FQH. So he responded by saying, look here, you're missing the point. We are not interfering in anybody's privacy as long as game of skill or game of chance are played without any stakes. If stakes are getting involved, then the state governments should be empowered to regulate it. This is the intention or the theme. And while saying so, has referred to the game of rummy, which Honorable Supreme Court in Satyanarayana has held it to be a game of skill. So the Constituent Assembly has made it clear, game of skill played with stakes will be betting and gambling. Third, the father of the Constitution, late Dr. Ambedkar, had also gone on record in his speech saying that if H.V. Kamath's request is acceded to, then states will become helpless. Betting and gambling may reach illegal heights and out of reach boundaries, and states will be passive, mute spectators. They cannot do anything. We can't afford that, and therefore we have to ring fence them, and that is how entry 45 list 2 later became entry 34 list 2, betting and gambling as a regulatory entry. So after 150 years of jurisprudence across the world, 75 years of constitutional theme which does not remain amended or rendered superfluous or overlooked. Of course, many judgments have not even discussed it. Though there are plethora of judgments, nobody has touched this aspect. So this is the view of the constitutional makers. 3. So once we have global, 2, constitutional theme in the Constitutional Assembly debates, and 3, the purport of entry 34 list 2. So it was argued by most of the councils quite vehemently and persuasively too, that you must read the entry as nothing but betting on gambling and not as betting and gambling. For which the court referred to various entries in the list 2. For example, insolvency and bankruptcy, markets and fairs, gas and gas works. So if you start substituting and or on as or as on, what will be the consequences of those entries? And relying on a nine-judge judgment and several other judgments, the court laid down three important principles. It's very important for us to understand as practitioners of tax law or practitioners of constitutional law. One, limitation in an entry can be read only when the words spelled out in the entry mandate such a narrow or limited interpretation. That's one ground. Because what are the rudimentary principle of constitution interpreting constitutional entries? Wide, expansive. That's the doctrine approach. So the converse is, if you want to limit, the express word should suggest what they call it as the language device formula. This is one theory. Now, the second important theory is you can do that to avoid legislative overlaps, to ensure each one's business is carried out by the respective federal partners without overlap. Not for any other reason, because wider meaning is the ground rule. So they have also said as a third important principle, very important, artificially narrowing down a legislative entry is prohibited in law. So artificial imputation or artificial restriction is unacceptable under the constitutional branch of law. And therefore, the court did not agree to the interpretation. It should be read as betting on gambling. Because why did they argue that? They wanted to say, if you read it as betting on gambling, only games of chances will be within the rigors of the law, games of skill will move out. When the phenomena across the globe is not to move out, you can statutorily protect if you want. If you don't want to protect, you can take that statutory protection out. But you can't take them out of the statutory definition of betting and gamble, nor can you attempt to take it out of the constitutional framework itself. To say you can bet and gamble on a game of skill, but you don't have any regulatory power is too far-fetched for any country to accept. Therefore, entry 34 lists to this construction, which was upheld by the Karnataka High Court and the Madras High Court, stood reversed. So this is the first. So we have three things: 150 years, 70 years of constitutional assembly, and third, how the foundation interpretation of this entry in its natural meaning. After doing all this, now the court starts to discuss the earlier views. May it be Satyanarayana, may it be RMDC 1, RMDC 2, Lakshman. Read any judgment. So, in sum and substance, all the judgments put together, what does the court seek to say? It says, when it comes to RMDC, the underlying game was only a game of chance. It was not a case where whether it's a game of skill or a game of chance, whether it's played with stakes or not, was not the issue decided in RMDC. And therefore, when we said this, they argued against us. Assessees as counsels, very powerful counsels. They said, if so, then why are they relying on RMDC 1? For which the learned judge has dealt it in two paragraphs, why it is significant. Because para 20 deals with an important doctrine, saying that unpredictability and staking on unpredictable outcomes is nothing but betting and gambling. That is the quintessence ratio of RMDC 1. If you're going to throw a blind shot, you may be the most expert statistician. See, can somebody say today some cricketer will score 100 or 200? You have to bet. However skillful he may be, when he takes the stance, takes the guard and puts the stance and ready to face the ball, he can be bowled on the first ball, or he can go on and on and on and score a century. However skillful he may be. that days. That is why that unpredictably gives the charm of betting. Therefore, RMDC, which deals with games of chances, deals with this ratio. And therefore, the reliance by the revenue to that extent is not incorrect, is what the judgment says. When it came to RMDC2, that was on a completely different. Here again, the conflicting game of chance or game of skill was not the issue. When games or skill does not affect public order. Now, do you need to regulate or not? So, what can be severable can be severed. What need not be severed? After all, who argued it? None other than our tax guru, our great Naniji. Nani Palkiwala has argued this case. So, there is a caution again uttered by the judgment. If it is going to impact public order or create an impact, social implications, then regulatory power can still be pressed into service. Is a ratio emanating out of RMDC2. So, the scope of entry 34 list 2, applying for regulation on games of skills, has been endorsed in RMDC2. That's exactly what the judgment seeks to say. Third, when it came to Lakshman, it is a shut open case, clear case. Simple. If you take the Police Act and the Gaming Act, it protects games of skill played in the race course, inside the race course, on the dates of the races. And 3 paragraphs of the judgment make it very clear. Somebody is within the race course, he bets on a horse, he is protected from Police Act and Gaming Act. Somebody is standing in the bazaar and betting on this horse, he will not be protected, he can be punished. And they said, horse race is a game of skill. Of course, Parasaran sir, who won the case, always would say, it's a game of skill for the jockey, not for the owner. That's the, I mean, such a learned scholar. He had fairly said this should have been the law. Doesn't matter. We'll take the law as it is. It does not harm us in any way. So, therefore, the point for consideration is when you bet inside the ring on a game of skill, the act protects you. What does it mean? It is otherwise betting and gambling. How do you say that when the same person goes out of the race course and bets, he's caught? He can be arrested, he can be penalized. This is exactly the ratio in Lakshman. Of course, then a series of judgment. This judgment also was kind enough to consider Mahalakshmi, the Madras High Court judgment, which extensively relies on Satyanarayana. That is why the main judgment does not read Satyanarayana separately. There was no need. Because Mahalakshmi has been discussed, Mahalakshmi interprets Satyanarayana intact, saying that playing rummy is a game of skill, no doubt about it. But playing for stakes makes it betting or gambling. Which is the ratio in para 12 in Satyanarayana, followed in Mahalakshmi uphill. Therefore, this is how the genesis of various judgments anterior in time during the initial nascent stage of constitutional interpretation have gathered momentum, acknowledging the fact that state have the regulatory power under entry 34 list 2 to regulate both games of skill and games of chances if stakes are being played. That is why, as a part of regulation, statutes protected game of skill and they did not protect game of chance, but both are betting and gambling. And that is why, of late, the judgment beautifully discussed that aspect. Every line you should spend to read. It takes a lot of time to read it, because it's a 700-page judgment. But every line is worth reading it. Especially young, upcoming lawyers, please take this opportunity to know. You will know foundational principles on tax law and foundational principles on constitution involving taxation matters. You will know it. It's an encyclopedia. Please read it. So, therefore, this is how this construction or interpretation has been made to bring home the theory why these judgments are inapplicable to say games of skill is excluded. What happened? States realized when it came to online gaming, it was not like playing rummy in a card room or in a part of a club as entertainment with some stakes being played. This is now an organized industry getting into the life of every individual who has a mobile phone and is able to click and credit amounts. Instant payment gateways. Mobile, instant payment gateways, and the platforms. Direct connect. And therefore, states realized we can no longer protect games of skill. And one state after the other started to pull out this so called protection under the Gaming Acts, under the Police Act. They started to remove it. And that is how Karnataka Act was challenged. That is how Madras Act was challenged. And what did these two high courts say? No, no, no. Etymologically, constitutionally, globally, games of skill played for stakes can never be called betting. Absolutely wrong. Absolutely wrong. No basis for such a ratio. In fact, the court has expressed its disappointment. How did the court come to this conclusion? When everything stands to the contrary, is what the court has expressed its view. Therefore, global, constitutional, a constitutional entry, and the interpretation. Now ask a question to yourself. Let's apply simultaneously common sense principle. See, when the speeches in the Constituent Assembly, when the entries is a betting, see, betting and gambling is like pipes and tubes, insolvency and bankruptcy. They go together. It's a flow. It's a common flow as understood. So, when all of these have made no distinction between a game of chance or a game of skill if played with stakes, do you think, let's put that question. See, judges like Vivian Bose have authored RMDCs. See what a weighty bench which has decided these issues in the past. Could they have called these and said games of skill played for stakes will not be betting and gambling? Ask that question to yourself before reading the judgment. Ask a common sense question. Could a 5-judge constitutional bench say this? Whereas 2 high courts have interpreted it so. And therefore, to reverse that ratio, you have to gather this much of momentum to ensure that the law stays on course. So this is then manifest arbitrariness. This all one very important principle this judgment has decided is when something is declared res extra commercial, you don't have any constitutional protection. It's a well settled law. Code distilleries, Justice Venkatachalya, Dada of a constitutional interpretation, has authored a leading judgment in Code distilleries on when something is res extra commercial, no constitutional protection. And if state decides to legitimize or legalize or issue licenses, then Part 3 will start to kick in. This is the protection given if states allow it to. Then you can Article 14, you can argue, 19.1, all that you can argue. Otherwise, if there is no protection and if it is withdrawn, then extra commercial will not have any constitutional guarantees. And therefore, the question of proportionality and all cannot be read into this constitutional scheme. It's a very important ratio on proportionality. Then they argued more importantly on nomen juris. It was a very effective presentation, I should say. Hats off to the counsels who thought of it. They argued, like they applied Gannon-Dunkerley to say, sale is construed to be a nomen juris definition. Therefore, if you go by nomen juris, Betting and gambling can only involve game of chances and not game of skill. The term gaming can only mean outright rejection on strong and valid basis of jurisprudence. Absolute treat to read this section of the judgment. It's a delight to read it. The way the judgment has been authored. It says, look here. See, what do you mean by nomen juris? Nomen juris is something which is not acquired as statutory import. People understand it as it is. It's nomen juris. All over the world, gaming stands defined through various statutes. They have chosen to include game of skill, they have chosen to exclude game of skill. We gave 1906 judgment, 1872, all this we are given. Where courts have said, if you play stakes on billiards, it is nothing but betting and gambling. Billiards is the game of skill. So, very clearly and evidently, gaming has been defined only through a statutory process. No nomen juris whatsoever. So when it has been defined through statutory process, your gaming acts chose to protect based on English law. And the same gaming act now takes the protection away. Simple. Once, see, I can protect, I need, because it's a statutory process. So online gaming, they don't want to protect it. So that is the question of a connotation. In fact, it vindicates the revenue's view. You protect only when something is betting and gambling. Otherwise, why should you protect? Was reaffirmed by the Honorable Supreme Court under this principle of nomen juris. Now we'll come to the last section of the first judgment, then we'll go to the second judgment. A very important principle. You must, all youngsters, I request, please read also the public order section of this judgment. So painstaking, the learned judge has drawn the ratios. See, public order is list 1 in item list entry 1 and list 2. First item, public order. What do you mean by public order? About 7-8 beautiful concepts have been discussed. For constraint of time, we will highlight 2. See, there are 3 possibilities when it comes to law and order. One, we term it as law and order. One, we term it as public order. And third, we term it as security of the state. These are the 3 broad buckets. 2 people drink heavily and start fighting in the middle of a street, creating commotion. It is a law and order issue because it is a fight between 2 individuals. It's a case of nuisance. It does and therefore affects or interferes law and order. The same 2 sets of people stimulate a communal riot. Then, from law and order, it travels into public order. And when this commotion started to, when it transgresses borders of states or borders of a nation, then it becomes an issue relating to the security of the state. So, security of the state is in the union list. The first 2 is in the state list. So, doctrinally, constitutional benches have evolved to 2 broad principles. What they call it, even tempo doctrine. You apply the even tempo doctrine and make a distinction between law and order and public order. And the second is the concentric circle doctrine. three concentric circles. The Supreme Court says, constitutional bench, the outer ring is law and order. The first inner ring is public order. And the innermost ring is called the security of the state. So, applying these two, and there's a third angle to it. So, because it's quite possible for somebody to contest, all this is about riots, all this is about tensions, all this is about aggressions. How can you deal this for a commercial operation? How will you apply the law? Therefore, the judgment chooses to discuss that angle also. What they call it, social and economic disorder is also public order. And refers to a very interesting judgment from Tamil Nadu, full bench of the Madras High Court, where Protection of Depositors Act was passed using state's power. So a question arose whether this will be under the banking law or under the regulatory law of the state. The Supreme Court says, because it was argued that it's unconstitutional, it is an overreach, and therefore in pith and substance, it is touching on banking regulations, which is governed by the union list. Rejected. Saying that even though the transaction is banking in nature, the manner in which the law has laid down its realms is relating only to the depository protection of the interest. It doesn't deal with banking operations, and therefore very much in the realm of the state law. In fact, this judgment here, even though there is no whisper about this judgment anywhere else because it was never argued and therefore not rightly decided, Union has passed the law prohibiting this from 1st May to 2026. These are the judgments which will help in arguing even that position. Because there is so many articles. This entry 34 used to Supreme Court again and again. So what will happen to the union's purpose? No, well protected. The purpose of imposing the union law, which we don't have to discuss it now because matter is sub judice, it's not right on my part to discuss, but the constitutional entries invoked under list 1 are completely for a different purpose. It can possibly cover betting and gambling as one of the spheres, but it is not on, prohibition is not on betting and gambling. The prohibition is on several integrated union entries and its operation. It's so expansive. It deals with technology, it deals with banking, it deals with currency, it deals with industry, it deals with several objective criteria put together and far and above reaching. And therefore, these are all the judgments which will help us in navigating our path whenever those matters also come up for hearing. So, holding it under entry 34 does not militate union's exercise of power, provided union has exercised its power within its constitutional bounds and under its rightful constitutional entries, which appears to be the case in this case. As matter is pending, I don't wish to discuss it any further. So, applying the public order test, this judgment concludes that with A, huge public is involved. B, every mobile is a virtual gaming house. C, addiction is of the highest rate. 4, monetary loss is incalculable. And therefore, the process of betting and gambling has become accessible and normalized. And therefore, it affects both event tempo theory and also the concentric documents as it brings within the ambit of public order. To close this judgment, this part of the first judgment, it's our duty to refer to one important document which the court has referred. Very, very important document, the preamble to the Tamil Nadu enactment, wherein it's a long preamble. I'll just read only one. 2 lakh teachers have been interviewed before they brought the legislation. 2 lakh teachers. And what have they said? They have said 74% have responded. So 74% have responded that they have noticed that concentration of the children have gone down. Several eye defects are noticed. 76% have said decrease in intelligent quotient, writing skills, and creativity of the students. 70% have noticed significant decrease in the self-esteem of the students, and 77% have noticed increase of anger in the students, and more than 72% have said they have noticed indiscipline amongst the students. 2 lakh teachers have been interviewed, and it also makes a note when 10,735 mails have been received, out of which 10,708, except 27 mails, 10,788 mails have requested for banning. And all of us know there are a number of judgments of the Supreme Court, constitutional benches. Regulatory power will include, regulation will include prohibition also. That's a well settled position of law under the constitutional theme. So, and to close it with, it says, you could have never imagined when overturning the Madras High Court and Karnataka High Court, it refers to the Hamilton Hediyas from the Quran to say this is exactly what it says in the second RMDC judgment. How would the court would have blessed the court puts the question, how did you assume that the court has blessed games of skill to be protected? It says, it is an abomination to play at chess, dice, or any other game, for if anything is staked, it is gambling, which is expressly prohibited in Quran, or if on other hand, nothing be hazarded, it is useless and in vain. Similarly, it records a judgment of the Madras High Court, where 2 courts, verse 934 and 939 of our celebrated Thiruvalluvar, who has said these 2 things. There is nothing else that brings poverty like gambling, which causes many a misery and destroys one's reputation. Gambling would preclude the 5 ratnas: reputation, education, wealth, food, and cloth from reaching the person. And when you do it in a mobile phone with an instant gateway, and the student population and the workman population is the major players in this game, numbering lakhs and lakhs, the court concluded this is an issue of public order, and therefore this can be banned also under that legislation. So this brings us to the end of the first judgment authored by Honorable Justice Patiwala. Now we'll come to the second judgment. In fact, I should have told Arun we need to do it in part 1 and part 2. I'm rushing for a lot of time. We could have done it in 2 parts.
So there is no need to rush, sir. There is no need to rush.
Understand, but still, I mean, listeners' uptake is also to be seen. Now, we will come to the second judgment authored by Honorable Justice Mahadevan. Extremely erudite judgment for the following reasons. I'll put the main issues for you to consider. The first ratio which the learned judge has decided is, which is very important. This is a very decisive judgment on the doctrine of proportionality in tax law. Defining judgment. See, in 6 years of our experience, often when constitutional validity is challenged in tax law, people are pressing doctrine of proportionality disproportionately. Every time, in every constitutional validity case. And every time we have been arguing to the contrary, most of the judgments have never dealt it. They have left it there. This judgment took the brave step of dealing it comprehensively and nailing it. It says, following the 9-judge bench judgment in Jindal Steel, look here, how can you think of a proportionality theory in taxing law? Taxing is a sovereign power. It's a sovereign right. The unconstitutionality of which can be challenged on the principle of arbitrariness. on the principle of discrimination, on the principle of classification, on the principle of right to carry trade. But how can you test an economic policy doctrine on the theory of proportionality? How is it sustainable? Because proportionality is more a contractual power, more a statutory power. It all started in service law, and it is slowly migrating in every law. And if you're going to migrate, if you're going to put this as one of the criteria, a constitutional principle, we can't draft economic policies the way it ought to be drafted. It is a serious injury which we can cause to people who draft policies sitting in the executive branch of the Constitution. It's a serious corrosion. So, this judgment, following 9 judges, decisively concludes no question of proportionality when it comes to exercise of choice of a sovereign taxing power. Penalty guarantee will come later. All penal statutes in tax enactment are always proportional. They always say they time it. But taxing power cannot be read through the reins or through the window of proportionality. This is one important principle they have decided. Now, the second principle, cardinal principle, which is very important. See, all of us concede goods will include intangibles because of TCS judgment. But what was argued in this case is not about intangible theory. They considered it as goods. But how can actionable claim be goods at all? That's the angularity which all the senior counsels and all the AORs, everybody argued, everybody was provided an opportunity, and they did their best. So they argued, look here, how can you say actionable claim is goods? So the court considered this core principle and ring-fenced it so beautifully. What has it said? A, look here, like gaming definition protecting games of skills. Time and again, every sales tax legislation historically has excluded actionable claims from the purview of goods, thereby endorsing the view it is nothing but goods. We are statutorily taking it out. So now to come and say, at a constitutional framework, actionable claims are neither goods nor services, it's a different animal, is unacceptable. Completely unacceptable. The exclusion vindicates that the statutory exercise has used its discretion not to term it as a goods. And the judgment did not stop there. It developed 2 more ancillary concepts. What are the 2 ancillary concepts? A, take the test for goods capable of transfer, capable of value, capable of securing the transfer through consideration. If it satisfies these ingredients, what is the harm in calling it as goods? Because transfer of property recognizes this. So it developed a second important concept. Ingredients of goods are embedded in actionable claim, and therefore, how can somebody argue that they are not goods? The second important principle. Now, the third offshoot, it comes very sequentially, one after the other. The third principle the court has decided is, look here, don't use your pre-GST commercial wisdom to decide a post-GST law. It's a very important ratio. Pre-GST excludes actionable claims from goods. Post-GST regime includes a section of the actionable claims as goods. Out of the 6, 3 are put in as actionable claims. Lottery, betting and gambling, and the casino, horse racing. So, when statute has exercised its power to do this. Trade was never able to show a limitation in the constitution. So constitution nowhere limits actionable claims to be called not as goods or services. No bar. 2, it has always existed through a statutory bar. Now, GST has chosen to lift this statutory bar for 3 of the actionable claims. So when there is no constitutional bar, when there is no statutory bar, how do you expect a court to issue a bar through a judgment? Is what this judgment is. You can't use court to write jurisprudence fixing limiting grounds on actionable claims. That's not the role of the court, says this judgment. Next, don't view from the clear scope of Transfer of Property Act and the Sale of Goods Act when you're testing a tax legislation under the GST, which is a futuristic, moving forward commercial law. See, let's test. It's a very important doctrine embedded in this judgment. See, even prior to GST, you had the Transfer of Property Act, you had the Sale of Goods Act. You still had the competence to draft a statutory tax legislation under Entry 54 List 2 or Entry 92 List 1 on sale as imposing either intrastate sales tax or intrastate tax. So there was always a tax legislation, even prior to GST, independent of Transfer of Property Act and independent of Sale of Goods Act. And in that, they chose to exclude actionable claim from the genre of goods. It's a statutory bar. So don't apply this pre-commercial law genres to a post-GST scenario, because this is a moving forward law. After setting this space in this judgment, it now starts to launch higher. How? It takes the definition of supply under Section 7 and defines, look here, what does the definition of supply say? It has the following ingredients. A, it is an inclusive definition. B, it is all forms of supply. And 3, such as sale, barter, exchange, etc., transfer, etc., etc., etc. So you have 3 terms which do not limit or restrict the operation or interpretation of the definition. Includes all forms of supply and such as. Therefore, don't think ever GST law has to be a sale-centric law. This is a very important ratio all of us should bear. See, like VKC footsteps, like Moti Minerals, if you call them as foundational judgments, these 2 concurring judgments will stand as pillars in improving the GST law, upon which whatever structure you can put, it will rest. It will stand as pillars. It can bear any weight and any load, because the way it has articulated these ratios are very important. So it says, don't ever imagine interpreting GST law as a sale-centric law. It is a supply-centric law. And therefore, it is all-encompassing. Every commercial transaction known to the world, if it gets supplied for a consideration, is amenable to GST. So this ring fencing is no longer, it uses the word traditional sale-centric concept and legally recognized forms of economic supply. This is how the judgment has, the terminology used in the judgment. Modern commercial transactions are not traditional forms of transfer. So this is the interpretation they have given to. Yes. Now, the last 2, 3 important concepts. Then this 1 hour and 15 minutes will be over by then. As he has capped my time to 75 minutes, and I am bound by it. I will not exceed 1 minute more. So, the next important concept is, see, they articulated a very important point. 2 important points. There is no question of an actionable claim arising at all in this transaction. You are actually taxing a direct tax activity. An activity of betting and gambling is being taxed. That was the focus on which this case was argued. It is a taxation on act of betting and gambling and not on actionable claims. Rejected. Why? See, you have a platform. 4 of us using our mobile log into the platform and remit 100 rupees each. Then the table opens electronically and allow 4 of us to play a game of rummy. And end of it, 360 rupees is out of the 400 is given to the winner. And 40 rupees is taken by the platform owner. So 2, 3 things were argued. This is the transaction. A, look here, my service fee is only 40 rupees. So why are you taxing me on 400? That's one issue. 2, look here, you are taxing the activity of betting. Where is the actionable claim? There is no actionable claim arising at all in this transaction. How do these two things get addressed? The court says, look here, A, you are not simply a platform provider. We can't accept it. You organize the whole game. You draft the rules. You prepare the schedules. You open the tables. It is not like 4 of us go and hire a platform, pay 40 rupees, and we play ourselves using algorithms. No. Everything is structured and run by them. So don't say you are a service provider. You are the conductor of the game. That's the starting point. 2, when 400 rupees is plowed there, it is plowed with a contingent future benefit in mind. All the 4 thinking they are going to win the 360 rupees. It is not a tax on payment. The judgment very clearly says it is not a tax on payment. It is a tax on the contingent beneficial interest capable of maturing into an enforceable. Exact language. Contingent beneficial interest capable of maturing into an enforceable claim. And therefore meets the definition of actionable claim. So it is not a tax on payment of who wins or who loses. It's a tax on organizing an actionable claim, collecting the actionable claim and giving it to the winner. Whole thing is structured. You cannot press one button or one card unless that 100 rupees is first remitted to them. And that secures 360 rupees up on hand in advance. That's why this quid cross theory, all that has been, there are detailed, a lot of things are there. You read the judgment. We have given you the map. You can now read everything. Quid clause. In quid clause, trusteeship is important. It should be in the nature of a deposit. And it discusses section 15. If it is a deposit, we will agree with you. It is not a deposit. The moment you credit, it goes. It goes out of your hand. Irretrievable. Unless game doesn't happen. Or the company is closed. Not before that. So quid clause theory won't apply. It's been stands rejected. So second, on valuation, when the whole if you call it a participation fee as 100, when you put the 100, it's a participation fee. The moment you put the 100, it becomes a stake money because you are expecting 360 rupees out of it with a chance to win using your game of skill. So the entire consideration, it is left to the legislature See, GST is not a net taxation, unlike income tax taxing on profits. It is a gross taxation law. So your entire 400 can remain intact for taxation. What is wrong? If the law under 15 provides you for that mechanism, the entire gross collection is the actionable claim, and the consideration for the actionable claim is 400 in nature. Why not 400 be taxed? You are collecting 100 from them, collect 118 from them, 128 from them. What prevented you? Having collected 100, why did you not collect the 28? Having collected 400 rupees, why did you not collect that 108 rupees? It's the question. You collect 4/5 of it. You don't want to collect 1/5 and keep saying, no, I'll pay only on 4. Whose mistake? It's our mistake. Whose mistake is this? Apply common sense. No legal sense is needed here. 4/5 of your collections have been made to protect your interest, but you compromise 20% of your interest, 28% of your interest not collecting revenues due. So this is the second point. Now the third point, they said, no, this is in the nature of wager under section 30. So this is not an enforceable contract with civil consequences, which is one of the mandatory tests in Transfer of Property Act, and therefore the levy should fail. Rejected. Because it assimilates the taxable event so beautifully. The taxable event is organizing the actionable claim to be paid. The taxable event is not contingent upon payment, where the question of enforceability will arise. The legal right of an actionable claim is enforceable. You already generated it in your hand. So that, for the purpose of tax, is dissectable at that stage. Which is what Sunrise said. See, in Andraj, they said you buy a lottery ticket for 10 rupees. They said it has two rights, the right to participate and the right to win. So you should bifurcate. Sunrise says no, smaller rights will get subsumed in the larger rights. And therefore it forms the cluster as one actionable claim. The same doctrine. You put your 100 rupees to win a 360 rupees, and that assimilation is something contract between the players and with the platform before it matures into 360 as a winning bid, under 30 as a wager. Because the taxable event is anterior in time, it survives 30. Is one of the important ratios laid in this judgment. Then after that, on C, yes, very important. They also argued, look here, you had a rate, you had the mentioning of the supply, but you did not have a tariff number, inconsequential. If you don't have a rate, it has consequence. If you have a rate, see, they applied one simple principle. They said, look here, GST law has not made any new experiment going beyond the territory of the constitutional law in drafting actionable claim as taxable. Why? What are the foundational principles of tax law? Is there a taxable person? Is there a taxable transaction? Is there a value? Is there a rate? If you are able to decipher all the four from a law, then why not GST law travel and then tax the transaction is the question asked. How is it wrong? In what way it is incorrect? Is one question. Then, therefore, a separate HSN in the initial years is no consequences. The main part of the judgment, we'll spend 5 minutes on that before we close at 6:20. We start at 6:05. 6 minutes, we close it. They are arguing. I mean, everybody is saying it is very, very difficult, unacceptable that you have made this legislation retrospective. You can uphold. We'll agree with all you say for 1 hour. You have spoken. All right. We'll give you the benefit. But how could you make it retrospective? This is a retrograde step. This is a frustrating step. This is sending wrong signals. Not at all. Not at all. How does the judgment deal with this 2023 Aman? Is very important. So you must understand the whole law in three parts. When the law was drafted in 2017, it brought actionable claims on horse racing, casinos, and betting and gambling as part of tax treatment. Can any one of them doubt it? Can somebody say it was not so? So you had a taxable event. Two, an actionable claim falls within the definition of supply. All forms and such as and includes. So you have a taxable event. Three, the platform owners who kept on claiming they only provide platform services unacceptable because contractually it's a non-starter. Without you, nothing can start from the end to finish. Except then logging through the mobile and paying that amount, rest of the thing is your obligation. So you become a taxable person. Four, the measure of taxation holistically is this 400 rupees. Therefore, 400 becomes the valuable consideration. 5, rate is 28%. So, when you brought the law in 2017, applying the foundational principles of tax law, Govincharan, Gangacharan, Mathuram, Agarwal, any number, Vatika, township, put any law, any judgment, constitutional bench and other benches. The law in 2017 gets validated. This is part 1. Part 2. Please read the GST minutes, 47th minute, 49th minute, GST Council minutes, and the 50th Council minutes. 3 meetings. Which all happened in 2022-2023 before this amended law was brought into force. All of them kept discussing that this is nothing but betting and gambling and stands defined so in the GST law. But courts are interpreting whether games of skill will be here, games of chance will be there, whether stake on games of skill is protected, games are not. All this is happening for now in numerous courts. So let court, the finance minister has made it very clear in the meeting. It's minuted. It's for the courts to finally decide whether playing for stakes on a game of skill is betting or gambling. Let them define. We will statutorily embolden them one more time in 2023. We don't want to wait endlessly. So it is like the canon judgment. When the first canon came on proper officer, section 5, 5A, 5B, 5C, all that was defined. What was proper officer stood expand just to meet the norms of the judgment. But when we argued before the full bench of the Honorable Supreme Court, we said the test is if you are able to sustain the legislation in its prior form, then the subsequent legislation should be declared merely as a surplusage, as an abundant caution. You see the entire GST minutes, 47, 49, and 50. Every word of it, every sentence of it. It clearly articulates this is nothing but betting and gambling. Because court process is on, we will statutorily define and let courts finally take a call. So it is an abundant caution amendment. That's the second step. And see the definition in 2023. What is specified actionable claim? Casinos, horse racing, betting and gambling. We have not done anything more. What was there in the we have put it in the new wine, in the old wine in new bottle. You wanted it this way? Okay, have it this way. We don't have a problem. It is not that we defined it for the first time. This is what everybody is conceiving, everybody is writing and speaking, which is wrong. These two parts should not be missed out. Therefore, what was the test? See, we had an onerous test to pass, which we passed. We told the court, test it on the basis of how the definition stood before amendment. Is there an actionable claim? Is there a taxable person? Is there a value? Is there a rate? If we satisfy that test, then this becomes a surplusage. It's abundant caution. See, in tax enactments, we can't wait endlessly hereafter. The volume of business is growing. So you need to definitely give certainty to it from a perspective without diluting your stand in the anterior law. Nowhere the GST Council has said, no, we have messed up, we have not defined at all, for the first. No. It says we have defined, but courts are taking different views. We will not wait for the final decision. We will move with the law, ahead with the law. And that is how this 2023 amendment becomes a surplusage. Were you able to sustain the law in its anterior form? We were able to sustain it. If we have failed, then what you say is right. Whatever people have written or spoken is right. We have not failed. Both the concurring judgments clearly say the law from 2017 defines this as an actionable claim which is taxable. So how can people say that no, you injected injury in the past? Not at all. Before 2023, show cause notices were issued, writ petitions were filed, contentions were made, saying that it is not actionable claim, it is actionable claim, game of chance, game of skill. Nobody argued. Not a single writ petitioner, any part of the country, in any court, has argued, no, there is no statutory backing to the definition. They said it will not be a form of actionable claim. That's a legal issue. They never questioned on vacuum or competence. Nowhere. So how can they turn back and say, in 2023, you have gone back in a retrospective manner? So these are the two broad judgments bringing out all these ratios, and in a very, very, very elaborate way based on earlier precedents, and very painstaking. The request, see, in 1 hour and 15 minutes, how much we can do. It's a hearing went on for 32 days, and it's a judgment running to 700 pages. So what best we could cover, we have covered in this 75 minutes. And we owe this to the Honorable Supreme Court. Once again, with a sense of deep indebtedness, we thank the court. And we thank all the counsels on the other side one more time for bringing a high quality jurisprudence through their arguments, which has resulted in this evolution of law. And it's a picture perfect judgment which anchors how this law should be looked with a futuristic mind. And at no point of time this law has decided the central law, not even remotely, not even a sentence anywhere. And the central law will rest its strength in its own might and in its own way. This judgment will not harm the central law, is our personal view at the moment. Since matter is pending, we don't want to articulate on that. And we once again dedicate this judgment in the memory of my late senior, Mr. C. Natarajan, but for whom none of you would have known who Venkataraman is. I bow down with gratitude. Thanks so much, Arun, and thanks all the listeners so patiently logging it for 75 minutes, listening a monologue of a man for this long a time. Pranams and grateful to you, please.
Many thanks, sir. We are already getting reactions from participants saying a great clarity, superbly explained. Thanks, sir. Can we take a few questions?
Sure. Provided I know the answers, I'll try to tell.
Sure. I'll take 4 to 5 questions. I know we have a 6:30 deadline. Varun Arora asks if GST rules 31B and C were in nature of clarifications, why were they introduced by way of rules and not by way of circulars?
It's a matter of legislative practice. As we said, we did it in canon. We repeated it here. You can, in fact, one more case is now being argued before Honorable Justice Vishwanathan. We are working one more case in the customs. Bringing a law for clarity cannot be read as a ground that the law was vacuum otherwise. May it be a law, may it be a rule. Doesn't matter. The test is not whether it's law, rule, or clarification, circular. The test is, can you argue your law without this amendment and sustain it? If you sustain it, then this is surplusage. Please read canon judgment. It's an authority on this point.
And sir, can I ask a follow-up? I'm assuming that be it Jao Fao, shelf drilling, in all those cases, I think that would be argument as well, right? So whatever you've done is only an additional safeguard. Am I right?
One, but in Jaw and FOW, we make it very clear it is retrospective. We don't have any fears in admitting it.
Got it.
We have
Got
made
it.
it very clear in the statement of reason itself, it is retrospective. Whereas this is not retrospective. It cannot be called in Jaw and FOW, we have called it retrospective.
Got it. Yeah,
That's the difference.
Amitabh Khemka asks, will government exercise powers under Section 11A of the CGST Act as the practice of not charging GST was generally prevalent in the industry?
See, it's for the government to decide, not for the court, not for the law officer. So it's for the government. It's between the trade and the government.
It's between the trade and the government.
They did not argue prospective overruling, and therefore that was not part of the ground, and it was not argued and not therefore decided. And had they argued, we would have opposed it. See, simple point is this: who asked you not to collect?
Right.
Who prevented you? When you have collected 80%, 85% of the whole transaction, what prevented you from collecting the balance 20%? And these are, if you see, 99% of the game is a 200 rupee game, maximum. It is not that 1 lakh or 10 lakhs. No. When you collect 200, what prevented you in collecting 56 rupees?
Mm.
You knock it at, ask that question at that level. And should government consider or not is something which you can answer. Government has to answer. I mean, we cannot speculate. We should not also do that. It's their choice.
Harshit Sharma poses this, sir. What is your view on entire stake being deemed a consideration for actionable claim, especially when participant and online platform both expressly agree that certain predefined portion of the stake is for actual bet and not for actionable claim?
Yeah, I agree. That is exactly the assimilation. See, what is taxed is what? Not the intrinsic profit. The judgment very clearly says it is not a taxation on profit or commission. GST law is a taxation on the gross. If you start doing this, then you will slowly dilute the law to say only profit should be taxed in GST, not the sale consideration. Here, what is the consideration? For you to get into the game for a stake of 360, you have to pay 100. So every 100 becomes a stake, a common pool. In fact, it says pooling. It uses the word in the judgment. It is the pooled consideration which becomes the consideration for section 15, which is gross.
Lalitendra Gulani has an interesting question, sir. The court has not addressed the issue of Section 74, which forms an issue of contention. In several cases, the orders were passed during pendency of writs. These orders were brought on record by way of interim applications. The court has not answered how these cases will be addressed.
I don't know, something which has not been argued is raising. I don't have an answer right now. If he's talking about bunching of show cause notice and all, conflicting, today you have reported one judgment from Guwahati in favor of revenue. So each court, like Jaw and Fob, each court is taking one view. And I hope it will meet the same fate like Jaw and Fob. If it is on bunching of show cause notice. Yeah. If it is on extended period or not extended period, that is something you have to go and factually argue your case. See, that is the question. Disclosure, non-disclosure, suppression, fraud and all. How can a constitutional court, how can a writ court decide it? You have to go back with your, see, they are given 8 weeks time to reply and 12 weeks time to adjudicate. And if orders have been passed, 12 weeks time to file appeals. In fact, officers who have logged in and hearing this, and I request the board also, I've talked to them, they have to issue instructions. 3 timelines are given in this judgment by Honorable Justice Mahadevan. 8 weeks to file replies and 12 weeks to pass orders. If orders have already been passed and then challenged, in 12 weeks to file appeal. So you go and argue at 74 suppression, non-suppression there, as a matter of fact.
Mr. Raghunathan poses this, sir. Should tax law be used as an instrument of state to enforce disincentive to gaming addiction?
That is why this law has traveled beyond entry 34 list 2 and traveled into list 2 entry 1 public order. This
Mhm.
travel and the kind of statistics they have produced. See, 2 lakh teachers have given their views on the student community, and nothing is less than 77% or 74%. Addiction, lack of concentration, anger, disinterest, money loss, suicides, deaths.
Yeah. Mr. Hari Kishan says this: would the revenues interpretation remain the same even if the platform merely facilitated a game of pure skill between participants and retained only a nominal facilitation fee?
It is not possible. See, if you have they argued this. What you say was argued. What did they argue? No, no, no. 100 rupees is a tournament fee, entry fee. See, in an entry fee, let us take a game of, say, cricket or tennis. You pay 1 lakh rupees as an entry fee to bring your team into contest. Then you don't stake who is going to be the winner. This is for the players to play. You have, say, 50,000 people to watch that match. 50,000 people pay entry gate fee and they enter the stadium to watch the match. They don't stake anything on the outcome. It is for pure participation for entertainment. So, if it is the nature of entry fee, no problem. But what you are doing is you put this 100 clearly on the term sheet. 1 out of the 4 will win and he will back 360 rupees. So it is not in the nature of an entry fee. It is for a reward. See, what is betting? In fact, the judgment defines what is betting. A, identified gain. B, identified stake. C, identified outcome, which is disproportionate to what is staked. This is the universal definition of betting and gambling. The judgment is recorded it.
Yeah. On the same lines, another question Mr. Bharat Kumar is asking: how can gaming platforms be distinguished in terms of platform B, in terms of platform fee? How can gaming platforms be distinguished in terms of platform fee with the e-commerce operators such as Ola, Uber?
Ola Uber has its own tax issues. Let's not bring them here at the moment. Let's now deal with gaming platforms, which the court has rejected that this is an entry fee scenario. They have rejected it. So there's no question of now dealing with it. It is playing for stakes, is what they have concluded. And I hope this is a lighter weight because some issues are pending for those operators. I hope you don't you don't stake with Ola and Uber thinking I'll pay 100 rupees to win a Ola car. I don't think you do that. You put that 100 to travel from one destination to another destination. That looks to be the difference.
So
Yes.
there are very surprising comments from three or four. Maybe an extreme example, but 3 to 4 people have put this comment, and I'm just putting across one of them to you, but it reflects the sentiment of a few more people. Why not consider share market and trading as betting? Because how much ever we research and analyze share market, uncertainty and unforeseeable situations cannot be foreseen.
See, it is for see, it is not a tax on a betting and gambling. Again, I'm putting it again. It is a tax on an actionable claim. GST law today is on actionable claim. Okay. Putting on your own shares and waiting for a return. If you see what is the difference between a bank deposit, a mutual fund, and the share market? In a bank deposit, no speculation. Put your money, you will get interest. In a mutual fund, you put your money, you are given fixed returns, they speculate. Whereas in the share market, you speculate. So This is not betting or gambling, because you want to earn a higher return out of it. You don't bet. You speculate, no doubt, but not betting. Speculation is yet to be classified as gambling or betting, I think, all over the world. Therefore, speculative trade is different from gambling and betting conceptually, is the commercial answer we give. But how the law evolves in future, we don't.
Okay. So should we wind up here? I think more or less we are done. So I'll ask one from my good friend, Deepak Joshi. I think he's Advocate Deepak Joshi from Delhi. Any views on the issue where online apps give lottery gifts upon paid subscriptions?
See, incentive discounts are slightly different from stakes. In fact, the judgment also records how the gaming platform is the service provider, how it incentivizes, how it chokes people into all that has been discussed very elaborately in the judgment, very extensively in the judgment.
So this is never ending. There are at least 15 more questions. So we will not be able to end this. The more you answer, the more queries we are getting. And yeah, we have to wind up at 6:37. I'll wind up with some comments on the webinar. And I thought we have quite a few comments. I'm reading out just some of them. One says, excellent, sir. Another, marvelously argued and explained. Great clarity. Deeply grateful for the explanation. Really, thanks. Wonderful session. Thank you to Taxsutra and ASG, sir. Crisp, clear. Curiosity to dive more, all in one package. Excellently summarized, sir. Very well put. Thank you for a mesmerizing talk. And there are others who are also congratulating on your 23rd anniversary of independent professional practice. A few more comments. None other than Envy sir can nail it so clearly. Excellent session. Thanks. Okay, crisp and clear. Excellent, sir. You're great and humble. I think that defines, sir. Great and humble. What a pleasure, sir, it is to host you. I know a lot of people have in mind with two terms as ASG coming to an end in just over 15 days. What are you finally going to do? But we'll keep that a mystery. We'll not unravel it today. Maybe we'll break the news after a fortnight. ASG sir has a lot to ponder over the next 15 days. But if you want, you all can bet on it, and there'll be no GST. Don't worry. You can bet on whether ASG sir will take a third term or not. You can bet on it.
But I'm thankful to all of you. I'm thankful to the Honorable Court, my good friends on the other side, and all of you for your patient listening. And more importantly, a special love and regard and thanks to Arun for organizing this.
Not my pleasure. Thanks
Very
to the
kind of you.
entire
Good,
team.
good comments for the
And
complex.
thanks to the entire team, Taxsutra team that has put this
And
together.
let me also take a minute in thanking those who have slogged it out with us. A young team of juniors in our office, headed by Chandrasekhar Bharti, Shiv Shankar, Abhishek, Nakul Madan worked a lot in this matter, Varshini. So a big team of people in our side. And we should also encourage and support the youngsters who have plowed their time. Each law firm who was supporting some senior, bubbling with energy, bubbling with enthusiasm, and so much of effort. You should really record it. That all the best to all the youngsters, and I take the best wishes from all of them, even though they lost and we won. Still, I hope grace demands they continue to wish me the best for whatever is in store, in whichever way it is in future. Pranams and namaste to all of you. Thank you so
Thank
much.
you, everyone. Have a wonderful week ahead. Thank you.
Thank you. Thank you, Arun. I'll leave.
Thanks. Thank you.